Thank you very much. Very helpful. And I know amongst all three lawyers, we've received about, what, $2,500 worth of advice, if not more. So very much appreciated. It's time for some questions. I just want to ask one for clarification, then open it up to my colleagues. Mr. Olson, I'd like you, if you could, to summarize the point you're trying to make in terms of what is subject to substantively, not procedurally. I hear what you're saying is that in terms of what is and is not acceptable as something requiring arbitration. I'm looking at the substance. One of the things that is of concern, I think, is the way these arbitration agreements end up sort of driving people's behavior. In other words, an arbitration, there are circumstances under which you really have no choice. This is of concern to me, is that you can't negotiate in many instances whether you enter into a mandatory and a binding arbitration agreement. If you want to go and get some kind of a phone, for example, I think all phones now require that you participate in mandatory binding arbitration. Are there any sort of subject areas where, given how you describe the FAA, that there is room for movement so that we can, you talk about you can't set different rules for arbitration than you have with regular contracts. I mean, it seems to me, just as a matter of fairness, that the circumstances under which you enter into a mandatory binding arbitration contract are very different. As an employee, you're looking for a job, you get an offer, but conditional of this job is you have to agree to mandatory binding arbitration. There's more, the analogy for me is like a gun to someone's head. Are you saying that most of the rules and requirements sort of ignore the basic underpinnings of how that contract was entered into in the first place? I think that's my question.
I don't think they ignore that in the sense that the standard rules applicable to whether it's how much you're going to get paid or whether you sign a non-compete, et cetera. The standard rules include, I believe it's Civil Code Section 1670.5, which is the unconscionability. They include unconscionability, and in California, unconscionability requires two prongs: procedural unconscionability and substantive unconscionability. Procedural unconscionability, and it's a spectrum, a scale. It's not binary, either yes or no. If you have a standardized form contract, that's probably somewhat procedurally one-sided, but it's not much, particularly given the ubiquity of standardized comment. If you have other procedural elements, if this is really something that's a necessity of life, if someone needs it that moment, if there's some element of duress or lack of real choice, and I would suggest that in many job situations there's not that, because there are many alternative potential employments that someone could look for. But it's a scale as to how difficult it is, how procedurally one-sided it might be.
So here's let me hone in for a second, because I think this could go on too long, and I want other people to and I know Senator Monning would like to speak as well. The honing in on just how someone has to negotiate in that situation. I mean, are you looking at the duress factor, or are you just saying sort of in the overall scheme of things, a person doesn't always have a choice? I think that's the concern. And how does that, is that an unconscionability consideration or not?
It is a consideration, and the flip side of that is that you also look to see how substantively one-sided something is. So you might have someone who has little choice in entering into something, but it may be a very fair agreement. It may be, I'm sorry, I'm missing his name, Mr. Dubois was saying, something that has a lot of protections like the AAA or JAMS has, in which case it's likely not to be found unconscionable. One of the things the California Supreme Court said in the Armendariz decision was that a party in a superior bargaining position is entitled to have a little margin of safety for their position.
Well, that assumes that it's just a small bargaining advantage. Let me just ask Ms. Gilbride to respond, and then Senator Monning.
Sure. So speaking of Armendariz, the other thing, and actually I would say the holding, the first thing that Armendariz said was that a contract of adhesion, so to back up a step, procedural unconscionability has to do with oppression and surprise is what the California courts have said. So it has a lot to do with unequal bargaining power, and then also terms that you would not expect that are, likely to catch someone by surprise. And with respect to unequal bargaining power, what the court said in Armendariz is that if an arbitration provision or other terms are presented as a take it or leave it contract of adhesion in an employment setting because of the inherently sort of coercive nature of the employment relationship and the lack of meaningful choice, that in and of itself creates procedural unconscionability. There does have to be substantive unconscionability as well, and that relates to the terms and how fair or one-sided they may be. But just if it's a take it or leave it agreement and it's presented as if you want this job, you have to agree to this, that is enough to create procedural unconscionability in California. And then, you also asked, are there any other areas substantively under the FAA where there's sort of a carve-out or an exemption? So I wanted to quickly speak to that. Besides the insurance one that I mentioned, there's also a provision within the FAA itself that says that employees who are engaged in interstate commerce as part of their job, so how that's been interpreted is truck drivers, people who are taking goods and moving them across state lines, they are not covered by the Federal Arbitration Act. And then the last, I would say, sort of catch-all situation, and it's sometimes hard to figure out when this will apply, but if something is completely intrastate, if interstate commerce isn't involved at all, or if the parties, by contract agree that their agreement is governed by state law, they're not engaged in interstate commerce, then you'll have courts saying that the Federal Arbitration Act does not apply, and you can apply state law without worrying about these preemption issues.
Sounds like a good appellate discussion. Thank you. Senator Monning.
Thank you, Madam Chair, and for organizing this hearing, for your staff. It's an important subject, and I want to thank the panel members. I look forward to hearing from the next panels and members of the public. I'll be brief, but the suggestion that we look at other requirements in a contract, for example, non-disclosure, non-competition, those I would think would tend to be applicable more to professionals for whom a review of a contract might be more part and parcel with the job relationship, the employment relationship. I think where we have the biggest problem is where you have real disparities, a consumer contract that isn't negotiated at the cell phone store, or an employment contract that, where it's not the subject of a collective bargaining agreement. Let's say a low-wage worker is signing the necessary paperwork, that even if you include an opt-out option, as was one of the recommendations, again, the sophistication of the consumer or employee is really going to determine, I think, whether that notice or that right to opt out would ever be exercised. The compelling argument about the protection of arbitration is, again, for a low-income person who may not have the resources to pursue a court case, but they may at least be able to be heard within an arbitration procedure. I guess my question is, are there other recommendations, and maybe this is a homework assignment for all of us, of how beyond disclosure, there's a way to bridge that gap, or maybe you think it's bridged just by the fairness of an arbitration proceeding, but what if in those disparate cases where you have a big corporation and a consumer, a purchasing consumer, that if that arbitration is part of that contract, that if it goes to arbitration, the resources be provided by the corporation to provide independent representation for the consumer in the arbitration proceeding.
Are you saying that the corporation hire counsel for?
They don't do the hiring, but the consumer has a right to be they have a right to be represented under most arbitration procedures. They don't necessarily have the means to pay for it. They may at the end, if they're successful, be entitled to compensation, or they pay their attorney through that award if they get it at the end. But there can be a deterrent from somebody even pursuing arbitration if they don't have the resources to be represented in that arbitration.
First of all, I do think that would be a special arbitration rule, because if that person were to pursue a civil action, they would not have that right to compensation in advance, or even under the American rule of attorney fees that California follows. Other than the specific statutory grants, there would not be a provision for that. So I think it likely would be preempted. I would also be concerned for the possibility of abuse.
Yeah, I'm just looking for ways to level the playing field, particularly in these disparate consumer-employee relationships to large employers or companies. I think maybe Mr. DeBow has a comment.
Well, yeah, I think it would be preempted, but what you could do is to avoid singling out arbitration, you could require that you maybe could put a cap on it or something, but you could say that in all disputes between a vendor and a customer of any kind, whether it's an arbitration or in court, the vendor must provide up to X dollars, or whatever you want to do, toward the attorney fees of the customer, whether you can get it passed or whether it's...
Right, and
another,
again, I'm just...
But that would not be preempted.
I appreciate that. And again, my guess is that's not going to be very popular among the business
I
community.
realize, I'm just saying that's the way to do it.
Right. Again, well, let's see what some of these other panel members think. I think, again, our challenge is you can have disclosures. You can establish rights and you can have disclosures, but it doesn't necessarily level the playing field in a disparate power relationship.
Ms. Kilbride, did you have a comment?
I just wanted to speak to your point about deterrence, because, you know, one thing that we've been focusing on this particular panel, I know the future panels are going to talk more about the reality on the ground, but we've been talking a lot about the law, and I just wanted to give us a little bit of a reality check, because, you know, you have a lot of empirical data that's come in, particularly in the last few years with the Consumer Financial Protection Bureau study and some other major empirical studies of arbitration, and one thing that you're finding is, you know, you have this proliferation of arbitration agreements. You don't have a proliferation of consumers going to arbitration, particularly over relatively small value claims, because of a lot of the things we were talking about, you know, the fees and maybe being, you know, intimidated, not having representation. And so, you know, the Consumer Financial Protection Bureau found only 25 arbitrations per year with AAA for $1,000 or less. And other, you know, studies have found similar things. And I think it is the imbalance of the playing field that has a lot to do with that. You know, the Federal Arbitration Act, if you look at its history, it was lobbied for and passed at the behest of business executives and business people who wanted to have a separate place where they could, you know, negotiate, to have experts in their field, you know, resolve disputes outside of the courtroom, and those were all negotiated, contractual, you know, arm's length agreements. We've moved so far from that with these terms that are just being imposed upon people, buried in fine print, where they have no idea until a dispute arises, and then it's, you know, so, you know, we talk about the courts being intimidating, but this idea, oh, you have to go to arbitration, there's all these rules, that can be just as intimidating. And so that's why you find this isn't an alternative area where people have the same substantive rights. What it ultimately winds up doing is suppressing claims.
Thank you. And again, I'll wait till later. You did prompt an idea, though. What if you had a dollar amount where you could still access small claims court on consumer complaints, for example, with consumer recourse, that you could pursue arbitration or small claims court if the cost of arbitration seemed too great? But I'll defer.
Perhaps we can, that would be an issue that we could also discuss. Before you leave, folks, we have, I think, just a quick question from Mr. Wachowski and then from Mr. Morlock.
It's a venue question. I think it's unconscionable that Californians who enter contracts here, have a breach or have a dispute here, have to go to Utah or Delaware. What would be wrong with the state legislature adopting a rule that that all arbitrations had to be heard here? I think, yeah, and here in California.
Well, the legislature has done that with certain construction subcontractors, that if the subcontractors in California, and if the building project is in California, if there's any dispute, the dispute has to be resolved in California. Now, that doesn't single out arbitration. That is whether you file a civil suit or not. And so that would be I believe, an arbitration neutral law. I think it would be problematic to say only arbitrations from disputes as opposed to all disputes, whether civil or arbitral.
Well, we had a case in California, the Negrampa case, which involved a franchisee and franchisor, and the franchisor's arbitration agreement required arbitrations to be conducted in Massachusetts, and the court said that was unconscionable.
Thank you.
Threw it out.
I think that might be an area. Mr. Senator Morlock.
Thank you, Madam Chair. Thank you, law professors. I'm not a lawyer by profession. I'm an accountant, but so I've really appreciated.
I knew you were going to do that.
I appreciate the lecture. It's been fantastic. The topic is federal arbitration, the U.S. Supreme Court, and the impact of mandatory arbitration. So I'm assuming that the U.S. Supreme Court and the California Supreme Court permit mandatory arbitration. And I just kind of want to know what the preview is. Where are we going? I've heard we should have the ability to have an opt-out provision. I've heard that we should have the AG play a larger oversight role. Where are we going? What's the magic wand? What do you want fixed?
Well, there's two things that have to be fixed, and right now we have a preemptive problem. I think there's two things that have to be fixed. One is to not allow a class action waiver in contracts, but again, that has to be if we issue a statute here that prohibits that, it will be preempted unless California law applies. And the Discover Bank case, which was overruled by Concepcion, unlike what Justice Breyer said in Nemburgia, that's invalid. It's not invalid. It's the law in California. And there's a case in California which involved a transportation worker, so the FAA didn't apply, and so that when the FAA didn't apply, California law applied, and I think it was a Gentry issue, not a Discover Bank issue, I think, and they applied Gentry to that case because it was California law. So that's one thing. The other thing is it's the same issue, though, of mandatory arbitration contracts. The people should have choices when they go into any kind of dispute resolution. And that's why, and they don't have that in a mandatory arbitration contract, nor will they have it, though, as I say, if they bar them. That's why, if we have a Federal Arbitration Act amendment, I like the opt-out, because that transfers the choice to the customer or the employee. And so that's my position.